So where we got to last time is this point. So we didn't actually finish intention. And most of you, I think, will be aware that we have an assignment. And I think this little piece on preliminary agreements is particularly relevant to the assignment. So I'm not going to shoo you away and say, let's go and look at it. Just go and look at my pre-recorded bit. Although I would highly recommend that you do go and look at my pre-recorded bit. So what we're going to do today is we're going to finish off talking about intention, in particular preliminary agreements. Shout out to, who was it? Is a person here who went to the Court of Appeal? Was it you, Chef? Who was at the Court of Appeal? Somebody was at the Court of Appeal and they heard a reference to Cumberland
last semester.
Ah, was it? Oh, okay.
Alex.
And Masters and Cameron. So Masters and Cameron's case today, and it's like being cited all over the place. When we've done that, I want to talk briefly about the second assignment. What I normally do in this class, and I'm just going to come out and tell you I completely forgot to do it, is I usually give you some sort of overview on the most recent assignment, so overview feedback. I just didn't prepare it. I'm not quite sure why. Happy to answer questions about it, but what I think I'll do is put the normal graphics together, because usually I give you a marking spread, the most common mistakes, that sort of thing. Rather than me just do it anecdotally, I think I'll just try and put something together and I can speak to it next week before this next assignment is due, if it helps you. But my apologies for that. It's all right, we've got plenty to talk about. We are going to then move on into certainty. We may not get to formalities, but we might, just see how we go. I did want to just do a little shout out before we start. The guys from Jade are quite keen to be more helpful in relation to research, and so they're offering to run a research masterclass probably next Wednesday. I just need to find out if there's interest in doing it. I've managed to book a room today. I'm going to send a note around. I was thinking, I know Wednesday is a day that there aren't that many first year subjects, so I thought it might be quite a good day. Then again, it could be the worst day because it could be the only day you don't come to class. I was thinking about trying to do it about 4:30 or so that those people who have classes, we could do it beforehand as well. So it wouldn't just be limited to using Jade, but would be around what kind of research tools are around and when you might use them, what they look like. So if any of you are interested in that, can you please let me know? I will be sending out an email to find out. I just don't want to ask Sue-Ann to come down to do something if people aren't going to show up on it. I'm going to offer a couple of different times to see what's most popular. I was thinking it might maybe 4:30. Just to give people the opportunity to do it before class, but it may well be that people are working then and struggling to get here at 5:30. I don't really know what suits. So I thought I might offer a couple of different options. But in relation to that too, if there are any particular examples of things where you've been stuck, the kinds of problems where you're thinking, well, what would I do? That would be good to get some insights to them so that they can plan something around that. So normally what they do is they'll pick a problem. They've offered for it to be a contract problem. So if lots of people can contract, I said, yay, go for that, because outsourcing my job is awesome, but it might be any kind of problem really. So we'll just sort of see what the interest is, if there is interest in doing it. So, okay. Preliminary agreements. So, a preliminary agreement is exactly what it says it is. Some kind of document or arrangement that the parties enter into prior to a formal contract. So sometimes it might be binding, sometimes it might not be binding. And so you can immediately see where and why intention becomes relevant. So has everybody had a look at the assignment problem? No. I've got some no's, I've got some yeses. I've got a copy of it there. But in short, our mate Dennis is being instructed by a New York law firm now, which I thought was quite nice. and their particular client wants to buy some shares and has entered into heads of agreement using Dennis's precedent. And some questions have arisen and you need to give some advice to the client, and you need to support that advice with, I'm just listening for what that siren means, and of course I don't remember, it's probably just a door window. You have to do two things. You have to answer Dennis's questions in a memo, and then you have to answer the client's questions in a letter. Dennis is the person who's going to have to sign off on the letter, which is basically what happens in law firms. The law firm, the named partner will sign. So Dennis needs to know before he signs the letter that the contents are right. So this time you've got two different audiences. You've got a memorandum of advice dealing with some specific legal issues that you're giving to your boss, a lawyer, and you are going to then translate some of those quite complex questions and ideas into a piece of advice for somebody who is not legally trained. Well, technically, your client, or you've been getting instructions from a guy called Harvey Specter, who is your New York-based contact, but he is not, whilst he is a New York lawyer, he's not Australian trained. You better treat him like he's not a lawyer. Don't assume that he knows everything. And the advice itself is going to the client, the ultimate client, Basil Gelt, whose the letters of whose names, if rearranged, may or may not be Bill Gates. I don't know. So, preliminary agreement. One of the first issues that we need to think about with the preliminary agreement is it an agreement at all? By agreement here, I'm talking about a legally enforceable contract. So we need to, one of the elements that we need to look at in order to determine whether we've got a contract or not is intention. So was it intended to be binding or not? So preliminary agreements are often expressed to be subject to contract, and the kind of question that we're asking ourselves is, did somebody intend to be bound, or did everybody intend to be bound? So, key case in this area is Masters and Cameron. And in that case, the High Court categorised preliminary agreements in three different ways. Sorry? The first is that the parties have finalised their terms and they intend to be bound immediately. So these kind of agreements are binding whether or not the formal document is signed. The formal document is literally just a formality. The intention is the parties would be bound. The second category is the agreement, they've reached agreement on terms, but the performance is conditional on execution of a formal contract. Everybody has agreed what they're going to do and what they're going to say, but nobody's going to be bound until the contract is signed. In that case, the parties are bound to execute the formal contract. So the only binding element of the agreement is the requirement to sign. The third category is that there is no intention until and unless the parties execute a formal contract. So note the subtle difference between 2 and 3. 2 is we've reached agreement on the terms, conditional on the final agreement only, nothing else, as opposed to it's not done till it's all done. And those last category, the third category, isn't binding. So, in Masters and Cameron, has anybody had a look at the case? Does anybody remember what the effect of the preliminary agreement in that case was? We've got our 3 categories. In fact, I've got the words here. The words in Masters and Cameron were, this agreement is made subject to the preparation of a formal contract of sale which shall be acceptable to my solicitors. Was their intention? Acceptable to my solicitors. sorry, so much gumph there.
I haven't read it, but I'm thinking it's number 2.
So why, what's your good logic? So
Well,
one of two.
There's an intention to enter into that contract if everything is agreed.
Any similar different views? SJ?
They're more towards the third because I feel like the requirement that it's got to be acceptable adds like a different.
Acceptable to a third party, so we've got a third party's view here. Sorry, I'm ending your sentence instead of repeating your sentence.
It's totally what I was going to say.
SJ saying she's leaning towards number 1 because there's a third party whose opinion matters here. That there's number 3. Sorry, no intention unless and unless the parties execute a formal contract. We've got votes for 2 and 3. We've got a vote for number 1. Okay, so those words, I have read the case, so I'm just putting words into SJ's mouth. I expect acceptable to my solicitors. What does that imply? Does it imply anything to you?
Certainty's not there yet.
That the certainty is not there yet, exactly. So we're talking about intention now, but the certainty is not there yet is the right kind of logic to follow. Certainty is not there yet because not all of the terms are there yet. We've got this implication that there might be things, but it's not not both parties solicitors either, it's just one party solicitor.
Is that I think I had a thought, but it might be wrong. Is that an illusory promise because it's subject, the performance is subject to the discretion of one party?
It could be actually, when we go into certainty and we'll talk about illusory promises, it absolutely could be, because you've got this really broad discretion. So my solicitors need to be happy with it. I agree on everything provided my solicitors are happy. The solicitors might come back and I don't like the price. It's not actually legal advice, it's nothing like that, but solicitor's not happy. Might have a solicitor who's manic depression. There's a lot of that going around, and that particular day, my solicitor's not going to be happy with anything. And I can get out, broad discretion. Basically, that's actually not helping you at all, that little extra animation, is it? Sorry about that. So the stipulation that the formal agreement was going to be subject to these additional terms that we don't know means that the memorandum itself is incomplete, and as a consequence, the intention of the parties was that more terms would be added. So that's how Masters and Cameron read, how the High Court read that, and said, at that stage it's a preliminary agreement only. The purpose of that document was to identify what the key terms would be, but it's not done till it's all done. All of the terms and conditions need to be pulled together. Subsequently, in Borkham Hills, the question arose as to whether or not there is a 4th category. There's plenty of academic writing on this if you want to get yourself caught up in the debate as to whether it matters whether there's a 4th category or not. But if there is one, it's that 4th category is that whether or not the parties might intend to be bound immediately or exclusively by the terms they've agreed on, whilst expecting to make a further contract in substitution for the first. So that in itself is actually quite similar to that. These animations are going to annoy me. To the 2nd category there. It's not terribly different from them. The idea that we're just going to replace it with this formal arrangement, but we're bound at this time. In such situations, the parties will be bound by the preliminary agreement. So whether there's a difference between the two or not, I'm not sure. I must admit, I'm not sure that I can bring myself to care overly. I want to be confident early on when one of those preliminary agreements are in front of me that it's either binding or it's not binding. And I want to be really clear on it. So where do these things come up in disputes? All the time.
Sorry.
So this is one of the... Sorry?
Can I just confirm? This is like the 2nd category.
So, which one?
That 4th category is similar to the 2nd.
Yeah.
except it's bound at that time.
At that time.
Whereas the second one isn't bound until.
So the second category there, sorry, I got to remember. I hate the way they call them first and secondary categories too, because I want to look at what the categories are. You're not bound by the larger agreement until the contract is executed, but you are bound to execute the contract. So it's just a timing issue more than anything else. Where the fourth category is you're bound at that time.
Straight away.
What does it really make any difference if you're bound to execute the contract anyway?
Yeah.
I don't know. But we get ourselves caught up in these things. These cases come up all the time. Talking to some students at the Gillian Triggs Higginbotham thing the other night, and there's a group of students who've been up at the Court of Appeal. Actually, Justin, are you at the Court of Appeal? Are you doing that again?
I did it last week.
So a few students were telling me that they, heard somebody refer to Carlisle and Carbolic Smoke Pole at one point. But Masters and Cameron was the case that came up a couple of times. So this stuff is in dispute all the time. It's one of the few places where reliably you can have an issue about whether contract formation has existed or not is in this intention space. In this space where commercial people have put a preliminary arrangement together, they're exploring or negotiating, and one party believes that they're further down the agreement track than the other. So the kind of problem that I've given you for this second assignment is it actually mirrors a circumstance I've been in myself. I'd like to say that the drafting of a heads of agreement is considerably better, but it's a situation I've been in myself on a number of different occasions. So some recent examples include this case, Pavlovic and Universal Music. I like this quote in the middle. So Chief Justice Bathurst, this is New South Wales case, says, let me read it. What is involved is the objective determination of the question from the communications between the parties in their context and the parties dealing over time up to the making of their alleged contract. So once again, we're using an objective test to determine, have we an agreement? Do we have agreement, offer and consideration, or a meeting of the minds? Do we have consideration? Do we have certainty? And the threshold test in these cases is usually, do we have intention? And when it comes to intention, our interest is not in what the parties actually intended, but what it appears that they intended based on their behaviours and their conduct. This case, this year, Edward Ted Lakis and Michael Victor Lakis, Justice Sakar says, for an agreement, either oral or writing, to be binding, the parties must manifest an intention to create legal intentions. This requires making an objective assessment of the state of affairs between the parties as distinct from the identification of any subjective reservation or intention. Straight to Irma Genus. Some more stuff about whatever. I like this one. This case was cited on, I'm going to pull it straight out of Jay this afternoon. This case was decided last Friday. Ask what is the meaning of what the parties have said rather than what did the parties say. What did the parties mean to say? I think that's actually put really beautifully. What is the meaning of what they said? Not what did they themselves mean to say. What did we hear objectively by listening to them? Okay, so going back to where we started from, in order to identify whether or not we have intention, we start with that threshold question. Can we see a voluntary assumption of an enforceable duty? Is that manifested from the behaviour, actions, statements of the parties? If there is no express statement, then we might look to the relationship that the parties have with each other. But since Irma Genus, that goes only really to the onus of proof. If there is an express statement, the effect of a preliminary agreement or a conditional clause, we need to pull apart the meaning of what was said as opposed to what they meant to say. We need to pull that apart using these categories in Masters and Cameron and potentially the fourth category in Balkan. Questions, concerns, thoughts?